Good afternoon, and thank you for joining us. This is Ashley McHugh from Insurance Newsnet, and I will be the administrator for today's webinar, Will 2023 be the year of the fiduciary rule? Moderating the webinar is John Hilton, Senior Editor at Insurance Newsnet. John has been with INN since 2015, following a long career in newspapers. Our panel today includes Jason Steeno, President of CoreCap Investments and CoreCap Advisors, and Pam Heinrich, General Counsel and Director of Government Affairs for the National Association for Fixed Annuities. Jason brings more than 25 years of experience in the industry, the last 20 years in various leadership and sales management roles at firms in both the retail brokerage and RIA space. In his current role, Jason focuses on driving scale, efficiency, and growth of the firm. Pam provides legal support and consulting services to NAFA's board of directors and nationwide membership relating to association governance, as well as federal and state regulations affecting fixed annuities transactions. Please ask any questions that you may have in the questions pane during our discussion, and we will be sure to get to as many as we can at the end. And with that, I'll turn it over to John.
Thank you, Ashley, and thank you to everyone for joining us today. We're really excited to have a pair of experts with us today representing a real cross-section of the industry to really help us break down this fiduciary issue. We've all lived with the fiduciary rule threat since at least 2015. Now, there's a mystery as to when it will happen, but we do expect a new fiduciary rule sometime in 2023. It's at least the second or third version. Things are changing all the time, and this time there are other rules, there are other regulators at work in the annuity and life insurance space. States are adopting best interest rules. The SEC has a best interest rule now. We're going to get to all of that. But first, let's get a sense of who is in our audience. So Ashley, I think you have our first poll.
Yep, our first poll is, what is your role? Are you a financial advisor, an insurance agent, in distribution, with a financial company, with an insurance company, support or back office, or you're just interested? We'll just give you a couple seconds here to lock your vote in. All right, John, it looks like about half of our audience today are insurance agents.
Great. Thanks, Ashley. I'd like to set the stage for our discussion here by welcoming our panelists and getting some general thoughts on the ongoing fiduciary rule saga. I know both of you have unique experiences to share. Pam, why don't you get us started with a little background refresher of how we got to where we are today.
Sounds good. Thanks, John, and thanks for having me. I really am excited to be here today. I'm curious, Ashley, if there was anyone that said they were just interested. I'd like to meet that person.
There actually were 3 people, yeah.
There were. Oh my goodness, you must be looking for something to do. All right, so I'm going to just go a little bit back on the history of how we got here. I would say that we go back at least to 2010. I think that regulators, both at the state and federal level, across product lines, across distribution models, across jurisdictions, have been working on enhancing or heightening the standard of conduct in the financial services industry. But for our purposes to talk about the fiduciary rule, the DOL did introduce a rule back in 2010. That was the first one. They withdrew that in 2011. And then, of course, we're all very familiar with the rule that was introduced in 2016 under the Obama administration. That rule was largely put into effect, not 100%, but largely put into effect before the Fifth Circuit vacated the rule in its entirety in 2018. So the effect of that ruling was to essentially reset the stage to the way of the world, prior to the 2016 rule. So we were operating in that world for a very small bit of time until July of 2020, under the former administration when they proposed a new fiduciary rule, a new prohibited transaction exemption. And that rule was allowed, not was allowed, but was finalized in December, late December of 2020, in the waning days of the last administration. The weird ruling or the weird Administration Procedures Act is that rules that are finalized within a certain time before a new Congress comes into play, the new Congress can essentially upend that ruling. And I think a lot of observers, a lot of industry stakeholders expected the new administration to disallow that Trump era rule to go into effect. But surprisingly, they did allow it to go into effect. And so that rule went into effect in February of 2021. Some of the documentation and disclosure requirements were finalized that summer of 2021. So here we are, a couple of years later, year and a half later. We knew right away that the new Department of Labor, in allowing that rule to go into effect, was nevertheless going to go back and take another look at what it meant to be a fiduciary. They talked about revising, amending, revoking, creating new prohibited transaction exemptions. So we've been kind of in this holding pattern now for almost 2 years, waiting for that other shoe to drop. And whether or not that happens this year or next year, it remains to be seen. But I think most people do expect to see a rule get proposed sometime this year. Meanwhile, the Department of Labor is fighting not one, but two ongoing lawsuits. So, you know, they've got a lot of irons in the fire right now. But so here we are looking at a possible, I would call it, John, a possible fiduciary rule 4.0, but we can quibble about the number, but yeah. So I also think it's sort of a job protection program for attorneys and interested parties. So we've been doing this for a long time and can expect to be doing it at least through this next year or so.
Yes, thank you, Pam. Very good to round up. I'm sure we'll be touching on those court cases again as we go along here. Jason, from the business end, you work with a lot of advisors. You can tell us what's going on the front lines. What has your attention as the Department of Labor embarks on another fiduciary rule effort?
So thanks for having me, John. I appreciate being here. Really, for me, what we're looking at is, you know, we've been operating under the current DOL rule now for almost a year, and have really gotten to a point where we've, you know, fulfilled what we need to do for that rule from a sales standpoint in terms of documentation, making sure that recommendations are being put in front of clients. Like, what is this new rule going to mean for that? You know, you get used to operating in the current environment and filling out certain amounts of paperwork, doing it a certain way. Is this going to upend that? Are there more documentation requirements that we're going to have to abide by? And I think for most of the folks that are on the call, anytime you add additional paperwork to an application packet, 2, 3 pages, 4 pages, additional things that you have to do, it kind of makes doing business harder. So that's really what we're looking at is we've gotten used to doing business a certain way. How are we going to have to change? And for us, we have roughly 190 agents with CoreCap, helping to train them and get them ready for this new rule once it comes out. And it can be quite an undertaking, even when you consider, you know, we're not that large. Imagine what it's like for very, very large firms out there.
Great, thanks, Jason. All right, so let's roll up our sleeves and get into this. So, like I said, the new fiduciary definition could be released any day now. Pam, I know you think it's going to take a little longer, but there's been a lot of work going on behind closed doors now. There hasn't been has not been very many leaks, so we don't know what's going on. Are you surprised that it's not out yet? And do you think there's a deadline at stake here so that this administration can get this rule out before the 2024 elections start to come into play?
Yeah, that's an important consideration, John. I'm not really surprised necessarily that it's not out yet. We've certainly, as I mentioned, the department has been signaling very explicitly, frankly, that it intends to do further rulemaking. It's been included in the regulatory agenda for the last 2 years. Including most recently the fall 2022 regulatory agenda. So that, place marker is firmly planted. I'm not surprised necessarily that it's not out yet, because I do think there are a lot of things going on with the Department of Labor, not only the 2 lawsuits that they're actively engaged in defending. It took a very, very long time to put in place a new Assistant Secretary of Labor, Lisa Gomez, who was recently approved by the Senate and has taken on her role as head of EBSA, which is the part of Department of Labor that's in control of this rule. But as you said, behind the scenes, the staff at Labor is the same and has been interested for a very, very long time in putting out a new rule or certainly amending the rule that came out in 2020. And so I think looking at the timeline, and I mentioned if a rule is finalized at such a late date in an administration, it's just a lot easier to uproot it when a new administration takes place. So I think that is an important blueprint perhaps for the current administration to want to back that timing up a bit. So, the rulemaking process requires a notice of proposed rulemaking to be published in the Federal Register, public comment period, which often gets prolonged by request of interested parties. In the last go around, there was a public hearing followed by another set of public comment period. And so I think that 6-month period prior to late December 2020 would definitely be moved up. So I think that that's at least a little bit of a tell, or should be, for the department to, even though in the last instance, the last administration's rule was allowed to go into effect, that certainly isn't something that can be counted on with a new administration after 2024. So I think that they have been working on this for a very long time, and I think they've got a lot of it written. I think it's just a matter of when would be the most beneficial timing to do so. Right.
The leaders might change, but the bureaucrats remain the same, right?
True that.
Yeah.
True
Okay.
that.
Okay, Jason, you mentioned a little bit your advisors, the concerns that you have, that they have out there trying to do business. What are some of the things that you're going to be looking at when this rule is finally published?
So I think the big thing that we're going to look at first is the timeline. So when it is published, how long do we have in order to really evaluate the rule itself? What is the impact to the business? How does that impact what we're doing today and how we're complying with the current rule that's out there? Not to mention training, right? So making sure that we can train all of our agents and advisors to comply with that rule and do it all within a time period that is that's somewhat reasonable. I think other firms that I've been at, we've started 2 years in advance of a rule getting ready. So that timeline, I think, for us is going to be really important to determine what's the sequence of events and how do we get everybody ready to be able to comply with that. Do we need to create new forms? And that's not even to mention working with vendors. Are our vendors complying? Are there things that we need to do with those vendors to get them ready to be able to support us as we comply with that new rule?
Okay, good stuff there. That right there, what you mentioned might be what a lot of our attendees are interested in. When we look at how annuities and life insurance are sold historically, what are some of those training things that could be changing? What are some details that you're looking at as you pull apart the sales process that maybe could be vulnerable to some of this new regulation?
Yeah, so I think it's really documentation is absolutely one of them. If we go back to the Reg BI in June of 2020, there were some disclosure requirements with Form CRS. Some firms like ours decided to use a conflicts disclosure document to help identify and communicate those conflicts. But at the same time, the requirement for actual documentation was what I would say fairly light. That changed significantly with DOL, where making sure that you're complying with the two impartial conduct standards, as well as putting your recommendation in writing in front of a client, having them sign off on it. So we've really had to adapt and adjust over the past 2.5 years as these rules have come into place. And I think that, over my career, I've talked to a lot of people about documentation, and, I think to some it's a 4-letter word to a certain degree, but at the end of the day, it's really, I think, the best thing that people can do nowadays is you can't document too much, because it's really going to be that important when called to the carpet, whether it's a complaint, a lawsuit, or what have you. So I think it just underscores the importance of making sure that you're documenting your conversations with clients, that you're keeping good notes, whether that's in a CRM, obviously the best way to do that, and ensuring that you are prepared should something happen down the road.
Sure. Yeah.
John, could I add a little?
Absolutely.
From an insurance only, or from fixed annuity sales through producers, I think one of the things that we're keenly looking at and concerned about is what the state PTE 8424 might look like in a new fiduciary rule. Just having a compliance pathway that's objective and that makes sense in our industry and within independent distribution is really critically important. And certainly the department has signaled a desire to take a hard look at 8424. So that's something that we're concerned about and we'll be paying attention to. But I agree with Jason. I mean, documentation and having a good client file is the best. It's the best thing for the client and for the advisors, really.
Yeah, so good points there. Every webinar that I'm on, it's 8424 is very important, stressed as very important. Otherwise, I hear a lot about the definition of a one-time advice, and historically there might be a one-time sale of a fixed annuity, and that's just the business is conducted there. But depending on what they decide with some of the language, this could turn out to be a very important distinction, if I understand it right. Pam, could you talk a little bit about why that is, and why the definition of one-time advice could be, really a crucial point here?
Yeah, absolutely. So in a rollover sale, you could be considered an investment advice fiduciary. You could be considered giving investment advice and if, or fiduciary investment advice. And if that's the case, then you have to satisfy all the obligations and requirements of being a fiduciary in that instance. So part of defining, or how to define investment advice, is through this 1975 5-part test. And one of the 5 parts or prongs, as they're called, is whether the recommendation or whether that advice was one time, or whether it's being given on a quote regular basis. So the regular basis is one of the 5 prongs, and it's probably now with the new interpretation under the 2020 rule, the one that's the most ambiguous. You have to satisfy all 5 of these parts or prongs in order for it to be considered investment advice. But the other 4 prongs are a little easier to satisfy, I would say. And until the new interpretation and until the department, as part of that 2020 rulemaking, withdrew a 2005 advisory opinion called the Deseret Letter. And in that advisory opinion, it explicitly provided a safe harbor, if you will, or said that rollover recommendations did not satisfy this regular basis prong. They withdrew that opinion. They said that opinion was in fact wrong. So that is no longer there. And then they said that while a rollover recommendation could be considered one time, on the other hand, it's of such significance, this decision to roll over workplace retirement assets into an IRA, or maybe from an IRA to another IRA, is so significant that it's probably the beginning of an ongoing relationship. And so it's dependent on facts and circumstances. It could be that the first instance of a recommendation becomes an ongoing relationship if the financial professional would subsequently make a recommendation about assets in that product, or make recommendations relative to some of the features of the product, and all of a sudden, boom, you're in an ongoing relationship. It's no longer one-time advice. So it's this one prong is very important in triggering that 5-part test that makes you a fiduciary. So we'll be looking at what they've already done a lot in the interpretation, but we'll see what they might codify or make more explicit in new rulemaking around that.
Okay, it sounds like that could be a point of contention.
Mhm.
And speaking of lawsuits, we'll segue there. Some folks on our call might recall that the fiduciary rule, the 2016 rule, as you mentioned earlier, was tossed out by the Fifth Circuit in 2018. And wondering why is this thing coming back again? Can you, Pam, maybe talk a little bit about why it was tossed out, and maybe I don't want to ask you to speculate, but just what to do to kind of get around that ruling?
Yeah, well, I think they're challenged. They will be challenged in writing a rule that satisfies the holding of the Fifth Circuit. Essentially, just in layman's terms, the Fifth Circuit said that the Department of Labor, in promulgating the 2016 rule, went beyond its authority. In revising that 5-part test, in creating a contract, a new best interest contract, and accompanying exemption, and creating a private right of action. They said that what the department did in that rule was contrary to the intent of Congress when it passed ERISA and created the 5-part test back in 1974 and 1975. They relied on a long-standing long time understanding of what a fiduciary relationship meant. And they said it meant that there was a special relationship of trust and confidence between an advisor and a client. And that generally speaking, typically that didn't exist in a sales transaction with a broker or a insurance agent. And so that basically was the holding. In the two lawsuits that are challenging the 2020 rule, essentially the plaintiffs there are saying that what the department did in reinterpreting the 5-part test in the preamble to the rule essentially was an end around that Fifth Circuit decision. So they're not doing it explicitly by rewriting the test, but they're doing it through interpretation, which the plaintiffs argue in those two lawsuits amounts to the same thing. So I think we can be comfortable in assuming that a new rule will not look exactly like the 2016 rule. It couldn't. It won't have a contract. But I think they're trying to thread the needle to support an argument that all of us that can get around that special relationship of trust and confidence that the Fifth Circuit says must exist in order for there to be a fiduciary relationship. So I think they will be challenged, but I think they're, that's not going to deter the department from trying to create a rule.
Do you think that we could expect to see a legal challenge of a new rule when it does come out?
I would absolutely say that we'd see a legal challenge. Yeah.
Probably.
As I said, this is attorney work protection. Yeah. No, I think we would, and it'll be interesting, really, to see what transpires from the two lawsuits. And one of the lawsuits is in the same venue at the district court level that feeds up to the Fifth Circuit, and that it was done purposefully. And so that's going to play out. And no matter who wins or loses at the district court level in those two lawsuits, I think we can expect to see the losing party appeal to this U.S. Court of Appeals for those two circuits that they're in. So this is going to continue to play out in the courts.
Mm-hmm.
I think.
Well, sure. Yeah. Speaking of liability, Jason, it's on everyone's mind. Could you talk a little bit about, again, from the front lines, the lawsuit exposure for agents and the financial institutions that back them, and how that concerns you?
Yeah, so I think anytime you have increased regulation or changes in regulation, obviously you have opportunities for missteps in complying with those rules and regulations. So naturally, with increased regulation, you're going to have a higher propensity for lawsuits or from individuals that just choose not to follow them. Right. At the same time, I know we're talking a little bit about keeping attorneys employed here as well, right? I'm sure that there are attorneys out there that are looking at these regulations and kind of looking at them as opportunities for additional business as it relates to agents, advisors, registered reps that potentially aren't following the rules or aren't abiding by policies and procedures that their firms have set up. At the same time, and I think even to a lesser hurdle or standard, is you have complaints. And when we're talking about investment advisors, registered reps, agents, for those that are registered reps and advisors, if you have a complaint on the insurance side of the business, that is disclosable, required to be disclosed on the security side of your business as well. So I think there's not only an opportunity for these lawsuits, but there is an opportunity for increased levels of complaints and folks U5s being marked up as well. You know, at the same time, as it relates to you know, as it relates to firms and as it relates to you know, other things that are disclosable, there definitely is going to be a higher level of these happening.
Mhm. Okay, good stuff. We've reached the halfway point. A lot of good material and information. I think I'll bring Ashley back here. I think we have a second poll question for folks.
We do. The poll is, what best reflects your level of training to prepare for tougher sales standards? Are you ready for anything? You have plenty of training, but there's still more to do. You have some training and change, but you're just not ready, or you haven't changed at all. So surprisingly, they're all relatively equal. It's about 30% each for the first three, and we have 3 people that haven't changed at all. But for the most part, it looks like it's pretty mixed.
Great, thank you, Ashley. Now let's pivot to what's happening at the state level and the SEC. As I mentioned earlier, there are other rules going on, and some of these efforts were not even contemplated when the first fiduciary rule was introduced, particularly at the state level. Really coordinated effort. I've covered state regulators for some years, and they usually do not move very fast. But on this best interest model, it has been really lightning quick. And Pam, I know your organization is involved in that effort, and maybe update us on what that effort is about and how it's going. How many states have adopted these best interest rules?
You bet. You mentioned something interesting, I think, John, that it started the work of the NAIC in revising model regulation 275, the suitability model regulation, actually began when the 2016 rule was being implemented, and it had not yet been overturned or vacated by the Fifth Circuit. So the lay of the land when the NAIC began its beginnings of its work on revising the model started from the premise that we were living in that fiduciary landscape. Of course, then in 2018, the court vacated it, and I think the NAIC shifted the focus a little bit more towards harmonizing with Reg BI and creating a best interest standard. And so NAIC created this working group that worked for almost 3 years on revising the suitability model to be a best interest standard model. And it was finalized in February of 2020 or 21, let me think. Anyway, and in that time, it has been adopted now by 31 states. And there are an additional 9 states that are in the rulemaking process somewhere along the line. So I think we could reasonably expect to hit 40 states, certainly by the end of the calendar year. And that's a pretty big number. And as you mentioned, back when they revised the suitability model in 2010 to enhance the suitability model quite a bit, it took a lot longer for states to sort of get on board with that, in my memory anyway. I think this has been a lot quicker. The NAIC is continuing to work on developing FAQ guidance and specifically looking at guidance around the safe harbor provision and producer training. So the annuity suitability working group is still ongoing. We're still engaged with that, along with our sister trades. And we're also engaged in continuing outreach to states to adopt. And I think what might be interesting over the next year or so is to see those states that either haven't adopted or aren't in the process. So there's another 10 out there, and those states include states like California and Florida and New Jersey, and so we'll see where they take it and how closely they conform or do not conform with the model regulation. But for most of the 31 states, they are very much in conformity with the model reg. I'd say they all are. I mean, some have a little bit of differences, but for the most part, and that's part of our ongoing outreach, is to try to keep the states as close to the model as possible. And so we've been successful that way.
Okay, just a quick follow-up here on that one. Now, there's obviously a lot of momentum going for state best interest rules. Meanwhile, the Department of Labor, as we've been talking about, is working on, its fiduciary goal. So can you talk a little bit about how those two approaches might clash and what might happen? I mean, federal rules, right? Would take precedent, right?
Yeah, it does clash, it would clash. I would say that all of the regulators profess to want to harmonize. And certainly, and Jason mentioned the impartial conduct standards. I mean, they're the thing that the fiduciary rule, the new one, the 2020 rule, the Reg BI and MDL 275 all have some commonality in creating a best interest standard for clients. In the 2020 fiduciary rule, that falls under that impartial conduct standards. I think where the conflict comes from an insurance point of view is the acknowledgement of fiduciary status that is required under the 2020 rule. And I think that's probably where the rubber hits the road in terms of not being in sync or not being in harmony. But I think they would be surprised. Regulators think that they're harmonizing. Not sure they're hitting the mark, but.
All right. And as I mentioned, at the Securities and Exchange Commission, the regulation best interest is enforced. And in fact, the agency is handing out compliance infractions already. So Jason, maybe talk a little bit about the impact of Reg BI and how will that fit with all these other rules?
So I think we're fortunate in that, and I say fortunate a little tongue in cheek. Since the beginning of 2021, we've had both, the SEC, first FINRA, the SEC, and then the state of Michigan in our offices doing exams for pretty much that entire period of time. So I can speak firsthand as it relates to our experience with Reg BI and kind of the things that we've done and we've seen from a regulatory standpoint. Really for us, it started with Reg BI and really ramping up the rationale that our advisors, our registered reps, and our agents are using relative to the products that they're selling or the recommendations that they're making with clients. Going back to Reg BI, creating additional documentation or forms that our advisors and our registered reps use and our agents use, whether it's for a fixed index annuity, a fixed annuity, a registered variable annuity potentially, things like that, where we're getting them getting them used to documenting that rationale and ensuring that they can explain how it is in the client's best interest, right? I think when you ask an agent or you ask an advisor, hey, are you operating in the client's best interest? Are you putting their interest before yours? Naturally, everybody's going to say yes. But sometimes that isn't always the case. And this really shined a light on what it means to put a client's interests ahead of your own. And it's been a bit eye-opening for us. I would say it's been a good experience, but at the same time, it hasn't come without challenges and without a lot of training and kind of helping people along in terms of what does it mean to be acting in a client's best interest, and how is this product better than where they were if we're doing a 1035 exchange or something along those lines.
Mm-hmm. Yeah, Pam talked a little bit about the harmonization of rules, and maybe regulators think they're harmonizing, but not really. I'll throw this to both of you. I mean, what has your experience been in working with regulators? I do remember back in 2016 that the common complaint was that the DOL bureaucrats did not know anything about how a fixed index annuity was sold, and didn't know what it did. So how can they write rules for something they don't understand? So what has been your experience with regulators? Are they receptive? Are they learning those things? And are you satisfied with the input you're able to give? I know it's what you do, Pam. So why don't we start with you?
All right. I think the frustrating thing is that we don't think that federal regulators really understand or appreciate independent distribution and what that means in terms of the ability to supervise or to be, if you were to use PTE 2020, the 2020 prohibited transaction exemption, how you could be a financial institution overseeing an independent insurance agent who might have appointments with, half a dozen or more different carriers. And so we've had multiple conversations trying to get the department to understand that challenge. I think that they don't, at the federal level, really understand all of the guardrails that are in place through state supervision and oversight through the departments of insurance at the state level. And I think they think it's a bit of a wild, wild west, that agents are doing whatever, and they don't understand that there's a lot of guardrails and checks and balances through market conduct and replacement requirements. I mean, it's not just suitability, and so I think that's makes it difficult to have rules that truly can harmonize with one another, because they're a bit of apples and oranges, and security products and security rules are, different. Being a financial advisor, being an investment advisor is different, as the Fifth Circuit noted, than being a transactional agent or broker. So, and I think the other thing that's frustrating is that they don't understand that independent distribution is really a good thing for consumers, because it just offers such a wider breadth of products and opportunities to find a product that suits their needs. And by sort of this regulatory overreach, you're gonna limit that or hurt that.
Mm-hmm. Any thoughts, Jason?
Yeah, so as it relates to my experience or our experience, there was actually quite a lot of harmonization in our three experiences with both, or with FINRA, the SEC, and the state of Michigan. very, very much looking for the same things in terms of what they were examining us on. So I think we might be a little further along than maybe what we might think in terms of kind of everybody playing in the same in the sandbox together as it relates to these rules. Clearly, the DOL rule was not in force at the time of two of those, but our experience has actually been very positive as it relates to Reg BI and those three departments.
Yeah, that's good. I'm thinking as we're talking here that we keep talking about how long this has been going on and different deadlines and rules that get tossed out, and along the way we've seen a lot of advisories and agencies that have just changed their practices and the documentation thing and really ramped up preparation for rules that never happened. So I don't think those folks would go back to doing things the way they did. So it's just a long way of me asking the question, do you think that the DOL is just wearing y'all down and we're just going to get there eventually anyway?
I think so. I think that this is the new normal. I don't see our industry going back to how things were even 3 or 4 years ago. We're preparing as if this is what we will need to do for the long term. And I think if you look at the regulatory stance, whether it's the current administration, things aren't going to go backwards. If anything, regulation is going to continue to tighten. We're going to be required to do more, disclose more, and ultimately, we're going to be doing this for the long term.
Yeah, I would say, yeah, I would agree with Jason. I would point out that whether you're operating under Reg BI or MDL 275, which is largely the law of the land or would be, you are being required to operate in the best interest of your clients. So that's never going to go backwards. I think that both Reg BI and MDL 275 expect and require better communication between the seller and the advisor and the client. Expect that you disclose more fulsomely your relationship that you have with the manufacturer of the product that you're selling and your licenses and what you can and can't sell, and that you're able to show your work if it comes to that. What did you say? What were the reasons that you chose the product that you recommended? And so I agree with Jason. I don't know if we're being worn down that we're all going to be fiduciaries across the board, but certainly, it's an enhanced and heightened standard of conduct that's not going to slide backwards. So,
and one other thing to add, John, and Pam brings up a great point. Operating in the best interest of the clients. I mean, a lot of times we talk about regulation in a negative light, right? At the end of the day, that's what we should all be doing anyway. Anytime we're interacting with clients, anytime we're making a recommendation of a product, the client is at the center of everything that we do, and we should always be putting their interests ahead of ours, always. So I think sometimes the connotation with regulation comes across a bit negative, but at the end of the day, whether it's the DOL rule, whether it's Reg BI, 8424, 2020-02, clients' interests should be put before ours regardless. And if in 20 years we're still doing that, and we've gotten to a point of much more clarity around what that means, what it truly means to put the client's interest ahead of ours, then I think we're still in a good spot.
Yeah, good point. Yeah. Well said. We did hear from a couple of folks on the poll that hadn't done anything, or maybe were not as prepared as they'd like to be. For those folks in our audience who might be lulled to sleep by now and not taking this too seriously, or those who are new to the business, I mean, what would you say to those folks that they should be doing? And I guess we should say also that there probably will be a comment period for this rule. I mean, folks should make their views known, I guess, but otherwise to just to be best prepared for whenever it comes. What would you say?
So I'll start with that one. I would say for those that are lulled to sleep or not sure what to do, or kind of haven't been paying attention, start paying attention right away, because the implications of not complying with these rules are extremely severe. Specifically the DOL rule, clients' IRAs potentially being disqualified, significant fines for the agent or the advisor. So it is one of those things that I think, as I look back in my 25 years in the business, of all the rules that have come out, it's serious. It has teeth, and it's not one of those types of situations where you can ask for forgiveness, because once the DOL starts getting complaints and there are lawsuits filed, it's going to be very public, I believe, when people are fined and things start happening. But at the end of the day, it's really about making sure that you can show what you did with a client. You have very, very well thought out documentation. You have good notes. You can explain why you did what you did for a client. Clearly, everybody's going to have different opinions as to what's right for a client, right? But to be able to at least back up why you made a particular recommendation that you did, making sure that you're documenting it, ideally in a CRM. I know some people still use notepads, things like that. Have something, have some documentation. Ideally, your firm is requiring that you do have that documentation. It is part of the current DOL rule. So, I can't stress enough. This is not an ostrich moment. Don't put your head in the sand, because for those that do, this is something that eventually it's going to come and bite you.
Yeah, I would agree 100%. I would say develop and hone best practices and make them consistent and repeatable. Again, show your work as Jason said, because the more you're able to demonstrate that you've had this communication with your client, that you've undertaken an analysis of their financial profile information, that you've thought through fully the products that you're allowed and authorized to recommend, and why you made that decision. So, for instance, in MDL 275, contrary to Reg BI, you don't have to have in writing before the client why you made the recommendation that you did. You have to communicate that, but it doesn't have to be in writing. But you do have to be able to document. You have to document and keep records of why you made that recommendation. So in that case, it's sort of a horse apiece. But I would say too, just take advantage of the educational and training opportunities that you have, either through carriers or marketing organizations or your affiliated firms, whatever. Just like as Jason said, now is not the time to put your head in the sand, and just keep good records, document and keep those records.
Sure. Yeah, good advice. All right, let's see if we have any questions. I think we have a couple. So Ashley, you want to shoot those at us?
Yeah, we have just a couple questions, and I got one into my email as well. Would you guys recommend recording virtual meetings? Is that a good idea?
I don't know. I don't know. Would you have to get permission? I don't know. Is that a thing, Jason? I'm not sure. It seems like you might.
I think by
depending on the state
default,
that you're in.
I think by default, when you record a meeting on Zoom, it lets the other party know that it
That
is
you're
being
recording.
recorded. I can see how there might be some benefit to that. I think the challenge would be retention of that.
Yeah.
Where is it
Maintaining it.
retained? When you're
Mhm.
talking about an hour-long Zoom meeting, the space constraints for something like that, and the ability to kind of pull it up when you need to might be a bit of a challenge. I've always found, because I've been a financial advisor myself back in the day, and using a voice to text for documentation seems to work really well. I try and use technology to my advantage if I can. So that seems to be something that works really well for those that don't like to type, or if you're like me and you can't read your handwriting after you look at it 3 days after. So
That prompted a thought. Maybe it just even makes sense to record it so that you can annotate it or record, document what the conversation was.
mhm.
But I don't know about hanging onto it for the required, depending on the state, 5 to 7 years or whatever.
Excellent. So do you guys know, are there any limits on client annuity concentration? For example, some firms are limiting their advisors to 50% of the client's liquid net worth in annuities. Is this an industry rule, or is that a broker-dealer imposed requirement?
Well, I can tell you that at CoreCap, we do have limitations. We don't typically publish them. But it's somewhat of a sliding scale, and it's very client dependent. We look at every client's situation really independently when it comes to those ratios or the concentration in annuities. Clearly, if somebody has a $5 million total net worth, and they're looking to guarantee a larger portion, and they have maybe $100,000 a year in expenses. Obviously, very simplistic example, but that could be a situation where going above that percentage might make sense for that particular client. So really for us, it's more of a case-by-case basis.
Great. John, that's all we have for today.
Thanks, Ashley. And I want to thank our panelists for sharing your precious time and insights with us today. I thought it went really well, and I learned some things. So Ashley, why don't you close us out?
Yeah, thank you for attending today's webinar. You will be receiving an email with a copy of the recording, as well as a link to sign up for our next webinar, Why Buying Life Insurance is an Act of Love, which will be on February 15th at 1 p.m. And thank you all, and have a great day.